Most of us have heard of the case where the Supreme Court placed limits on the freedom of speech. However, most people don't know the name of the case and frequently misquote it. A recent case out of Kansas once again brings into question the government's ability to criminalize certain types of speech. From the Schneck case in 1919 to the Hernandez-Calvillo case in 2022, when government tries to make speech it doesn't like criminal, we the people must stand up to the tyranny. So we'll discuss this case next on the Constitution Study. Well, hello there, everyday Americans, and welcome to the Constitution Study. This is where we read and study the Constitution, and we teach the rising generation to be free. I'm glad you could join me. Listen, I want to let you know that I'm going to be giving away a free book. Now, you can find out more details at the Constitution Study. All you have to do is sign up for one of my mailing lists, and voila, you get an entry for a chance at a free book. I'll talk a bit more about that at the end, but right now, let's talk about these cases involving freedom of speech. In 1917, Congress passed the Espionage Act, which declared, "Whoever, when the United States is at war, shall willfully cause or attempt to cause insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States, or shall willfully obstruct the recruiting or enlistment service of the United States, to the injury of the service or of the United States, shall be punished by a fine of not more than $10,000 or imprisoned not more than 20 years, or both." Now, Congress also passed an act to increase the size of the U.S. military, including using a draft. To draft into the military service of the United States, organize an officer in accordance with the provisions of Section 111 of said National Defense Act, so far as the provisions of said section may be applicable and not inconsistent with the terms of this act, any or all members of the National Guard or the National Guard Reserves, and said members so drafted into the military service of the United States, shall serve therein for state the period of existing emergency unless sooner discharged. Now, not surprisingly, there were many Americans who were not happy with the idea of a military draft. Mr. Schneck, a General Secretary of the Socialist Party, was authorized by it to produce and distribute 15,000 leaflets stating that the draft violated the 13th Amendment of the Constitution of the United States. The case, Schneck versus United States, is where we get this mythical prohibition against yelling fire in a crowded theater. In that case, the Supreme Court stated that freedom of speech could not be used as a defense for illegal actions. In the case of United States versus Jose Felipe Hernandez-Calvillo and Mauro Papalozzi, Mr. Hernandez-Calvillo and Papalozzi were charged with using illegal aliens for labor in their sheetrocking business. When the case was heard by a jury, they found the appellees guilty of conspiracy, but not of actually encouraging or inducing people to come or to reside in the country illegally. Now, the appellees asked for the charges of conspiracy to be dropped because Title 8 of the United States Code, Section 1324 A1A4, violates the First Amendment by criminalizing speech. Specifically, this law claims it's a crime for someone who encourages or induces an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence is or will be in violation of law. Now, the case before the district court focused solely on the constitutional challenge to Section 1324 A1A4. So how should the court look at this case? As when interpreting any statute, we start with the statute's plain language and assume that the legislative purpose is expressed by the ordinary meaning of the words used. As I've said before, if you want to know what the law means, you start with the plain meaning of the language. So does subsection A4 abridge the freedom of speech? At first glance, the answer seems to be yes. Sure, you can induce people by offering them money or other services, but you can also induce by verbal persuasion. And the plain meaning of the word encourage involves speech. Of course, not everyone agrees with this point of view. From the dissenting justice, an ordinary definition of the word encourage might be, as the court suggests, to give courage to, inspire with courage, spirit, or hope, to hearten. But that definition is somewhat vague. In keeping with the principles of statutory construction, we should strive to find a more precise definition of the word that still comports with its original meaning. Yes, words in the English language can have different senses based on context. But as a wise man once said, when you hear hoofbeats, think horses, not zebras. Put another way, the simplest answer is generally the correct one. Is the definition of encourage vague? Just what evidence is there that when Congress used the words encourage or induce, they meant felicitation or solicitation? The government maintains that the Ninth Circuit, and thus the District Court, misread subsection A4 because the statute does not use the words encourage and induce in their ordinary sense. Instead, the government asserts it uses them as synonyms for the criminal law concepts of felicitation, also known as aiding or abetting, and solicitation. In other words, the government reads subsection A4 as targeting those who facilitate or solicit others to engage in certain illegal immigration activity, specifically unlawfully coming to, entering, or residing in the United States. And to the extent that a person could facilitate or solicit this activity using speech, the government says the First Amendment would not protect such speech. So which is it? Was Congress using the ordinary meanings of encourage and induce, or the more legalistic definitions? Now, putting subsection A4 into context, we have our answer. Other language in Section 1324 confirms that Congress used encourage and induce in their ordinary sense, not in their more limited and specialized criminal law sense. For one thing, if Congress intended this specialized meaning, there would be potential overlap between subsections A3, conceals, harbors, or shields from detection a non-citizen, and A4, encourages or induces an alien to come to, enter, or reside in the United States. Where does that leave us on the question of the First Amendment protections? Can Congress make it a crime to merely encourage someone to break the law? Again, from the dissenting justice. The court makes this case much harder than it need. If we consider an ordinary, common-sense definition of the words encourage and induce, together with the Supreme Court's instructions for overbreadth cases, 8 U.S.C. Section 1324A1A4 is a solicitation statute and nothing more. To be sure, the government overplays its hand by suggesting it also encompasses felicitation. Nevertheless, that is an inadequate reason for us to declare the statute unconstitutionally overbroad when it is otherwise subject to a reasonable and constitutional construction. If I say you should do something, I may be encouraging you, but is that solicitation, which is defined as earnest request, a seeking to obtain something from another with some degree of zeal and earnestness. If we're looking for the simplest answer to that question, then I think our conclusion should be pretty clear. The district court agreed. Ultimately, subsection A4 cannot bear the government's limited construction. The ordinary meanings of encourage and induce encompass both conduct and speech, and nothing in the statutory language or surrounding context suggests that Congress gave those terms a narrower meaning akin to the criminal law concepts of felicitation and solicitation. While the words encourage and induce could be used as part of a description for solicitation, the court found nothing to indicate that Congress meant anything other than the ordinary definitions of these words when they wrote the law. Now, since both encouragement and inducement can be done with simple speech, then the law, as written, is too broad, allowing for infringement of a person's speech. In the end, the comparison of subsection A4's constitutional and unconstitutional applications is one-sided. Based on the government's examples, the statute mostly, if not entirely, proscribes conduct already made criminal by other statutes. We are therefore not convinced that invalidating subsection A4 would deprive the government of a critical enforcement tool or leave wide swaths of criminal conduct unpunished. And as much as there are some legitimate applications of subsection A4, they pale in comparison to the illegitimate ones. The statute's plain language is susceptible of regular application to protected expression, reaching vast amounts of protected speech uttered daily. For these reasons, we hold that subsection A4 is substantially overbroad under the First Amendment. Accordingly, we affirm the dismissal of this indictment. Which brings me back to Mr. Schneck. See, while the outcomes of these two cases are different, there is a lot of similarity in the details. Both involve Congress attempting to criminalize speech. In Mr. Schneck's case, it was providing information to encourage people to resist the draft because it was illegally indentured service. In the cases of Mr. Hernandez-Calvillo and Papalozzi, it was encouraging people to break immigration law. Now, from Schneck, we got an often misquoted opinion claiming that you can be charged for speech without actually committing a crime. And from Hernandez-Calvillo and Papalozzi, we have the court recognizing that plain, ordinary language of a law, absent evidence to the contrary, is exactly what Congress had in mind. What I do see here is a court saying, if Congress meant to be more specific, then they should have been. The next question is, will this case be appealed to the circuit? At this point, I don't know. Now, have Mr. Hernandez-Calvillo and Papalozzi used solicitation or merely speech? Again, I don't know. As the court noted, other subsections of the law provide for more specific crimes, but subsection 4 is so broad as to include speech in general, not specifically solicitation. If we are to apply subsection 4 equally, then many politicians, pundits, and everyday Americans would be guilty. Just think of how many people, from the President of the United States to state and local officials, have encouraged or induced aliens to enter or reside in the United States, knowing that doing so would involve violation of the law. If Mr. Hernandez-Calvillo and Papalozzi were found guilty of subsection A4, then the law would require a large percentage of our politicians, pundits, and media personnel be found guilty as well. While that idea may appeal to some, the damage it would do to our rights and the Constitution of this nation would be far worse. So again, here we have a case from the district court where they said, listen, Congress meant exactly what it said. If Congress wanted to mean something different, they should have said so. I find this case interesting because it's another example of a court actually applying the language of the law, not trying to become another political arm. And this is good news. This is the type of judgments we want from courts, not to impose their own political preferences or try to suss out what popular opinion is, but to look at the laws, decide if they meet the supreme law, and then apply them fairly. So I'm quite pleased with how this case came out, and I'm curious if it goes any farther. Now, if you want to learn more about these types of things, again, the Constitution Study is a great place to start, and I'll be giving away a copy of my book for people who register in the month of August for one of my mailing lists. I've got several that I'm running at the moment. Just pick one, and your name goes in the hat. Also, if you'd like to see me in person, I am setting up events around the country. Right now, I've got dates set for my Blessings of Liberty tour up in North Dakota, Idaho, and Wyoming. I've been in contact with people in Pennsylvania and Delaware, and more people in Texas, and I even have some people in Tampa, Florida area that are interested as well. Now, if you'd like me to join you, come to one of my locations or simply fill out the form and have me come to your location. This year, the focus of my talks are the blessings of liberty and how we get them back. So check that all out. Just go to constitutionstudy.com/tour. But the biggest thing you can do to help me is twofold. One, you can go to the store on that page and maybe pick up a copy of one of my other books or a mug or a shirt or anything that you can do. That obviously helps pay for all of this stuff. But the biggest thing you can do is share this information. Take all the stuff that's on, all my articles, all my videos, everything that's on Constitution Study is free for you to use and free for you to share. So feel free to take it, send it to friends, family, social media, wherever. If you know somebody that does interviews, some member of the media, I love doing interviews. Maybe pass it along to one of them. And if you want to join a group of scholars that are studying the Constitution and sharing this information, check out constitutionscholars.com. Those resources are there to help you meet other scholars and share information. And all of that's there for you. You can join in absolutely free. Most of all, though, I hope that you found this worthy of taking the time and effort to share. And I hope you found it worthy enough that you'll bring some friends next time as you join us here again for the Constitution Study.